Unveil it. That's the main topic of the discussion. We're going to discuss about the consulates opening in India right now for the visa applications, more than what they used to be. We also have, we're going to cover on USCIS closures because of the weather conditions in the United States. For the fingerprinting, for the interview, what are the steps that need to be taken? We will also cover the topic, if you are being arrested for DUI, have been charged with DUI, what are the things that you need to take care of? All these things should be, we're going to cover this in this. Along with me is my business partner, Revocation. Sorry, we are a little bit different look today, as we had issues with electricity, we have issues with internet, we have issues, our office building was closed because of the weather conditions. So please excuse us if by any chance we get cut off. It's because either we lost the electricity or we probably lost the internet connection. Rebecca, on the Biden's bill, we know that I see some great topics that are getting raised, and they're not going to use the word aliens anymore. That's something that is very good. They're not going to use the word illegal anymore. They're going to call undocumented aliens. That seems that, I mean, that just the wording itself in the law, looks to be a preamble for me. How the law is going to be designated. What are your expectations of the bill?
Yeah, definitely. We're optimistic. With the language is definitely signaling a more immigrant-friendly stance. So the administration's new bill, the U.S. Citizenship Act of 2021, is what it's being called. It's expected to be introduced in Congress this week, and for the most part, it seems to. We don't have the text of it yet, I don't think, but it covers the same priorities that the administration outlined on the first day of the administration. It covers a lot, including things related to asylum, the immigration court system, which all need a lot of attention also. On the employment-based side, I would say some of the kind of main highlights of what the administration has said that they want in the bill are clearance of the employment-based immigrant visa backlogs, recapturing unused immigrant visas that in previous years were not used many years ago, reducing lengthy wait times, eliminating per country caps, which would make a huge difference for green card processing, especially for people who have been waiting for several years, prioritizing STEM degrees and STEM occupations for employment-based visas, and making the H-4 EAD a statutory matter so that it's no longer this regulatory thing that is kind of debated in the courts. So those are the kind of main highlights that they have outlined so far from the first days of the administration. And so we're hopeful to see that in the introduced bill. Rahul, do you think it's going to be a more comprehensive bill that gets passed, or more piecemeal?
It's definitely, Biden is going to definitely promote the comprehensive bill for sure. With the help of Senator Menendez, he's going to introduce. I don't know how far it's going to be bipartisan. To what extent we do expect senators to support the bill from the Republican Party, we don't know. Definitely, they do have an upper hand in the House. I'm not expecting any problem whatsoever at all in getting this bill passed in the House. Senate is a problem. If they do away with the filibuster rule, which requires 60 votes to pass a bill, though, they may have a good chance. They may have one or two senators from the Republican Party join to pass this bill. They may have one or two Democratic senators might oppose this bill. Overall, if they do away with the filibuster rule for this particular bill, that should be able to clear the desk of the Senate easily. I don't know whether it's going to be a marathon or is it going to be a 200 meters run or 400 meters run. For sure, it doesn't look like it's a 100-meter run. Biden administration doesn't look like he's looking for a marathon to take it for a long and stretch it for a long period of time. He had the mandate. He just came into power. He wants to do it in the first 100 days itself. In the first 30 days, he wants to introduce a bill, which is going to be on February 20th at the most. and then he should be passing the bill pretty soon. We have to see how the Senate and other things will work out, Rebecca. Rebecca, on the closure of the immigration offices and the biometrics offices, what's going to happen with the people? I mean, they're ready to go for the interview. They couldn't go because of the weather conditions. Local mayors and some of the governors told not to go anywhere. What will happen to these people, though? Will they reschedule? Will they cancel? Will they deny the applications?
Yeah, so officially the place to look to see if a local USCIS field office or an application support center in ASC, that's where the biometrics are taken. There's a website on uscis.gov for office closings. Make sure you're looking at the official uscis.gov website. If you just Google USCIS office closures, there will be that official website there. That's where officially office closures that have been confirmed are being posted. We have had problems with USCIS posting those updates ahead of time. There was a lot of questions throughout the day yesterday, which was President's Day, so USCIS would have been closed anyway. But just asking about appointments that are scheduled for this week. If you go there, I would say a lot of the offices in kind of the more dire areas have already posted confirmed closures for today and the 17th. I haven't seen too much for the rest of the week, but that's where you should keep checking. If the office where your appointment is scheduled shows that it is closed on the day that your appointment is scheduled, you do not need to do anything. Your appointment will be automatically rescheduled. You'll get another notice in the mail. We can't say when that notice will arrive. It may take a few weeks, hopefully not several weeks, but it will be automatically rescheduled. We have been getting a lot of questions this week about what to do if the office that you're supposed to go to on Thursday, for example, doesn't show yet on that website. Should you still plan to go? That's really hard to say. I've been advising my clients to use your best judgment based on the weather situation on, closer to that time. I definitely would not risk
I would advise, I would also advise for them to take into considerations what the mayor of the city is saying and what the governor of the city is saying and what the judge of the county is saying. They should consider that. If the mayor says not to go, most probably USCIS will honor it. If the governor says not to move around out of your home, the USCIS will definitely honor those things, though. It's not going to be disastrous if by any chance you don't go, especially in the weather conditions. We have seen a lot of times in these kind of conditions, USCIS, even in the Trump era, we have seen them very flexible, though. Very flexible if you don't go. So if I were, if the conditions are bad, it's very tough. I tried to go to office yesterday. I couldn't even take my car off. I don't know, it's just flying wherever I'm not from Detroit, so I don't know how to use the car. I had to go on bike, and when I went there, the office was closed. They put the whole building was closed, and they said the electricity was not there, so they closed the whole building. So, yeah, I would say that you should take risk in meeting with accidents or any physical risk to go to the office. I wouldn't recommend that. Rebecca, with regards to the consulate, are you seeing the consulates getting more open in India right now?
Yeah, we have heard reports that visa appointment scheduling in U.S. consulates in India has seemed to be getting better. As many people know, the past several months, it's been almost impossible with the nearest appointment being several months out or a confirmed appointment being canceled last minute and rescheduled for weeks later. It does seem like appointment availability is increasing. It may be the kind of local situation. If it's improving, they may be opening up more capacity per day for in-person appointments, both non-immigrant and immigrant visas, from what we've heard.
Rebecca, there are common questions that come out that if somebody who's on a non-immigrant visa get arrested in the DUI, what is the consequences they normally face? What are the steps involved? Can you walk through? Let's say, for example, I'm here on F1 visa. Let's say I'm here on H1B visa, stamped, and I have a validity until 2023. I'm on H1B, and I get detained for DUI. What are the consequences? What is the short-term consequences? What are the long-term consequences?
Right. So if you are in the U.S. and you get ticketed or pulled over or arrested for a DUI or DWI, you can expect that your non-immigrant visa stamp, the stamp in your passport, will likely be provisionally revoked by the consulate that issued that stamp. And you may or may not get notification of that. We have had people receive emails directly from like the consulate in Chennai or the consulate from where they got that visa stamp, informing them that your visa has been provisionally revoked because of a DUI. You may or may not get that email. But what that means for your status, it doesn't mean that you are out of status. It does sound serious that your visa is revoked, but that visa stamp in your passport is needed when you are outside the country trying to come into the US, applying for entry into the US. So in effect, if you're here in the US in F1 status and H1B status, and you otherwise are not violating your immigration status, then that DUI and provisional revocation of your visa by the consulate doesn't affect your status here in the US, as long as you do not leave the country. Once you leave the US, that's where issues come in. So we would definitely recommend that anyone in that situation consult with an immigration attorney, especially before you book any international travel, because once you leave the country, in order to get a new visa stamp, even if the visa stamp in your passport is not expired, it will be considered revoked by the consulate. And they have pretty good systems or databases where local law enforcement DUIs are somehow sent to the State Department, and they seem to have pretty good databases and systems. They seem to find out about them pretty well. So even if it's not expired, you need to get a new visa stamp before you can come back into the country. That will usually involve going to a physician that is authorized by the consulate, by the State Department, to get a screening done. They basically, the physician needs to screen you to sign off that you are not what they call a habitual drunkard. That's kind of the immigration law terminology. And once you get that, you can apply for the visa renewal or the new visa. That process takes about an additional 3 weeks from a normal visa processing at the consulate. So you need to factor that in. So keep all of that in mind for DUIs, for your non-immigrant.
What about the green card, Rebecca? Will they face any problem in getting the green card? What are the steps they need to do when they go for the green card application?
Right. So if you're applying for adjustment of status in the US, you're filing the I-485 application. On the form, you do need to disclose. There's a question at the end of the form asking if you've ever been cited, arrested for any criminal matter. So you do need to check yes for that and explain it. Just explain the circumstances, when and what happened. And if that is your only kind of criminal offense, for the most part, it is not too detrimental for your overall green card process. You can still get the I-485 application approved, but you should expect that you will be scheduled for an in-person interview at a USCIS field office before you can get the green card. Even if they're waiving in-person interviews for other employment-based applications, anything with a criminal matter will usually require an in-person interview. But if it is just that kind of a single DUI or DWI, for the most part, if you're honest about it, upfront about it, and disclose it in the application and in the interview, it is not detrimental to your overall application. If there's anything additional, any other criminal matters, definitely consult with an attorney.
Let's go to Q&As, Rebecca. I'm going to go with some of the questions here. Question from Ashok Kumar from Facebook, he has a question. His medicals expired, and what does that mean is that for the 485 application, if you filed an application and if you've submitted the medicals, if it's more than 2 years, the medicals are being pending with USCIS. That means that they expired. And he has now received a online information saying that his RFE has been issued and his priority date is current. Ashok, that's the good news that you got it. I mean, that is the best news that you can have it. That means that your file is worked on and they looked into it. They found out the date is current and they found out your medicals has expired. That means that they are going to issue the medicals RFE. They may issue some other minute things like having your company to file a 485J supplement. They may issue sometimes also to file the G325. Some people have corrected me saying that G325 form does not exist, it's gone, but they still tell us to use the G325 form to submit the 5 years employment history. So they may ask all these questions, but Ashok, if you were my client, I would be so happy. Even if you're not my client, I'm still happy for you that you got an RFE. Not many times I feel happy that people get RFEs, but this time, definitely it is a good news for you. Raghu Shet from Facebook has this question. On October 30th, immigration has received his application and his checks are not clear. Now, I'm not sure how he said is that he applied on October 30th or did the immigration received on October 30th? Those are two different things though. I can say that we haven't filed any applications in our office. We filed everything received by October 29th though. So I don't have a good track, but I can say that all applications that have been received by the immigration on or before October 29th have been cashed. There may be 1 or 2 cases that we may have not received the receipt notice, but every case that we've been filed on or before October 29th have been cashed. I got some information, some people saying that we didn't receive, the check is not cashed. Definitely, if it's October 30th, I'm a little bit worried about it. But I will still give maybe 2 or 3 days to see if it's going to get cashed. Maybe end of this week because weather conditions are bad right now. But that's definitely something doesn't sound good for Raghu for me.
Sai from YouTube is asking if there's any update on the HL ban being lifted. That's a good question. At this time, the executive order, the presidential proclamations are still in effect, the ones that bar new H or L visas from being issued at consulates abroad. There are several exceptions. If you were in the U.S. It seems like any status, even if you were in the US in F1 status as of last June, you can still travel and get that visa stamp according to kind of the wording of that proclamation. But people who were not in the US last year, who are going for their first H or L visa, technically that ban is still in effect through the end of March. We are hoping that the administration will take action soon to revoke it because they can pretty easily, and they have indicated that they're open to doing that.
Max and from YouTube and Mikit from YouTube and a couple of other people from YouTube and Facebook are asking me to predict the priority date. They're asking me when the priority date will move. They're asking me when, how does it sound in October of 2021? Assuming everything stands as it is. One thing I can tell everybody is that I am the worst predictor of the priority date. Believe me, I have written evidence, I have video evidence, I have Spotify evidence, I have radio evidence that I am the worst predictor of the priority date. I did not predict the priority date will move to 2015. Definitely, it looks like there are about 380,000 green card applicants that are waiting in the consulate to be adjudicated according to the information that we have been given. But we don't know out of the 380,000 how much of them are immediate relatives, because immediate relatives will not fall into the category of they will not fall into the business immigration. But the preference categories, that means that the first preference, U.S. citizens, children who are above 21. The second preference, which is green card holders, spouses, and children who are unmarried. and also third preference, which is married children of citizens, and fourth preference, brothers and sisters of the citizens of the United States. These people, we call them as preference categories. There is a quota for them. If they don't use the quota, they will fall into the business immigration. We have to see how many will. We do surely expect people, some visas to be falling into the business. We don't know, even if they fall into the number of applications that were received by the USCIS stands to be more than 400,000 green cards applications in the month of October. Most of them seems to be from Indian nationals. So this is in the business immigration. That's information we got it. So we don't know if they would move, if they would not move, but I would say that I'm the wrong predictor. There are many other different ways of predicting the priority date. The best thing is I know one thing called parrot predictor. The guy sits in the road and he picks up the parrot thing and he tells the thing. And that guy is far better than I am. And believe me, a lot of immigration lawyers fall into the same category. I wanted to explain why it is. I couldn't explain, but that's the end of the story of why I'm wrong in the predicting the priority date. Question from Rahul Ambati from YouTube. I'm pursuing my MBA on H4 visa. Can I take up the unpaid internship in the summer? On the H4 visa, unpaid internship is not legal. There may be asked question, but it's unpaid. Why is it not legal? The rule of the immigration says that if you do not have a work permit, you cannot accept any employment that you expect some profit at a later date. For example, an unpaid internship, if you're going to a law school and then you want to become a lawyer, for example, Revocation was like that. I mean, we did pay her a little bit, not much at the time when she was working as a law clerk. But even if there are some law firms that don't pay, they take the law clerks. So let's assume that Rebecca was on H4 visa, and then she's coming and working as an unpaid intern in Radian and PC. What is her intention? She wants to learn the things so that she can get a gainful employment, either with the Radian and PC or with some other law firm. Either way, that is considered that it's not a voluntary job. Now, if on the contrary, though, if she would have been gone to a church and she is volunteering to teach a Chinese language in the church, does she expect after becoming a lawyer to be a Chinese language teacher in a church on a Sunday from 10 to 11 every single day, every single week? Absolutely not. Most probably that is a voluntary job. So if you're taking an internship, though, it definitely is an intention that you're going to profit at a later date. So we do not consider that as a legal method of you to work or to, again, unpaid internship there. Now, if you do have an EAD, it's completely different question. Since you don't have an EAD, we are answering this question to you.
Gia from YouTube was asking if she could change her employer while her H-1B extension is pending, and her EAD card is also being extended. So it sounds like the renewal's in process and waiting for her green card. So whether you can change employers while your H-1B extension is pending usually depends on whether your I-94 for your current approval notice has expired or not. Before the expiration date, it's pretty easy to change employers if your current H-1B has not expired yet. After the I-94 end date, it becomes trickier because you may need to wait for that H-1B extension to be approved first. However, because you also have your EAD card in process and that you're waiting for your green card, that says to me that your I-485 application is likely filed and pending. So on top of that, for changing employers, you need to factor in the possibility of using AC-21, which is where you can, as Rahul mentioned earlier, you can change your employer after 180 days of your I-485 application being pending. So I would, Gia, if I were you, I would consult with the attorney that filed your I-485 and find out if you were able to do that, to use AC-21 if you're eligible to use that, to switch employers so that you don't disrupt your green card process.
Rebecca, do you recommend to use the same lawyer or a different lawyer, though? I may recommend him to use a different lawyer.
Well, if it's the lawyer that filed her I-485, technically that lawyer represents her, but it could also be the same lawyer that filed the I-140 on behalf of the company. So that's a good point. The lawyer that filed the I-140 on behalf of the company may have a conflict of interest if they're advising you on leaving that company. So you may want to consult with a different attorney that doesn't have a conflict of interest.
Kumar has this mind-blowing question to me. Will this final action dates ever move? Why are they stuck? Yes, we are expecting the final action dates to move somewhere maybe in May or July, somewhere at that period of time. We're expecting the final action dates to move, though, because they will gauge the number of applicants that are getting the green card, and based on that, they will move a little bit faster in May to July. That is our expectation, though. It normally moves, final action date moves May to July, and from there onwards, it may move very fast depending on the applicant number of green cards that are still available. And filing dates normally move in October and November, but final action dates between May and July is the typical time they move.
KP from YouTube recently filed his I-485 with the I-140 downgrade to EB3, and his company is planning to change its name soon. And will that affect his pending green card application? So KP, if it's just purely a name change by the company and there isn't any kind of corporate restructuring, acquisition, no change in the company's federal tax ID number, then it won't really affect your green card application in any way. If it's purely just a name change, you may just need to update it in a future interview or RFE if you do receive one for that EB3 I-140. If it is a situation where the company's structure ownership is changing such that it's a different tax ID number for that company, then you do need to have an attorney analyze exactly what the corporate change is and determine if there's a successor in interest relationship there with the new company and the old company. Even if there is not that successor in interest relationship, if your I-485 has been pending for 180 days before that change happens, your new company could file that J supplement for you. We've done that before when a company was acquired and taken over by another company, and your green card can continue as normal if your position will essentially remain the same.
Question from Prawn. If my spouse moves to EB3 EAD, I remain on H1B. In future, EB2 moves faster. Can I apply I-485 in EB2? That's going to be tough. The reason is that once she moves to EAD, though, she's an adjustment of status. If you're going to, I'm assuming that if you're going to file an adjustment of status for you on EB2, though, then how is she going to file? Because to file an adjustment of status, you must be on a non-immigrant visa status. That's one confusion, though. The other thing is that there are some ways where you can do interfiling, where you can move EB3 and you can file the EB2 also. However, though, these things, what happen is that they keep moving back and forth, back and forth. There's a lot of confusion in the interpretation of the interfiling. I would recommend, though, if by any chance EB2 moves forward, you should consult a lawyer before you take any steps. And overall, these are things that are very sensitive to each family, though. What should we do and what should we not do? We put a good video on 180 days, a video after you file the adjustment of status. We want you to watch that. It's not a Tuesday live that we did. It was a separate video. It was done about 2 weeks ago. We want you to watch it. Maybe it's worth for you to have a consultation with a lawyer and make sure that when you do the consultation, have your spouse also be available there. Personally, myself, I don't want to maintain the non-immigrant visa status for a long period of time. I know there are things you move to EB3 and then EB2 may move, and then you move to EB2. Guess what? EB3 moves fast. I've been through LA. I mean, I go to LA once in a while. My son is in LA, so I go there. And the problem with LA lines are you're in one line. Guess what? My line never moves. As soon as I move to the next line, this line moves. My line doesn't move. And it's just so, sometimes it's maybe worth, man, I'm going to just shut down myself, sit down and not do anything, stay in my line. And that's something that you can do, because when you want to change lanes, you may have to maintain your non-immigrant status at all times. And to maintain the non-immigrant status, it's not easy. I mean, for a family of two people to maintain the non-immigrant status continuously until you get a green card each year, the company might have to fetch a lot of money. Filing fees may range anywhere between $450 to all the way to $6,500 for one single person. And then you do have to maintain the H4, you have to maintain the H4 EAD. Is it all worth for you to do all these things? Now, if I have a kid who's a teenager and who is born in India, then definitely I would not, I may not want to move to the adjustment of status unless the final action date becomes current. But if I am in there in the adjustment of status is pretty safe. You can stay there for a long period of time. I will be very inclined going towards letting my non-immigrant visa status go. And maybe I will not change the lanes like the way I do in LA. Wherever I go, I get frustrated, change the lane. Guess what? Every time I do, the lane I move from the other lane, the lane that I moved from moves. And yes, it happens. EB3 and EB2, historically, EB2 are very advanced for Indian nationals, though. But when you look into, don't look history-wise EB2 for Indian nationals. I want you to look into the Chinese nationals. Look into it, EB3 and EB2. Which one is faster, though? Guess what? It changes every month. Every 2 months, it changes. We are expecting the same in EB3 and EB2 for Indian nationals, too. It may keep changing. So I may be inclined towards getting married to the adjustment of status. That's me. But I can go wrong. Remember, I'm the worst guesser in the priority date predictions.
We have a couple of questions about approval notices. First, if an employer loses an H-1B approval notice, is there a way to get a duplicate, and how long does it take? So yes, you can. The employer can apply for a duplicate by filing an I-824 application. It's a pretty simple form, but the downside is that it's slow. It takes about 2 to 4 months, and there's no premium processing to expedite that. So it is difficult if you have lost that original H-1B approval notice. There's also a filing fee of about $460, I believe, to file that I-824 to request a duplicate H-1B approval notice. That needs to be filed by the petitioner who filed the H-1B. And then Arjun is asking, I'm assuming he's asking in relation to an I-140 approval notice that his employer or the petitioner is not providing to him. He's asking, will filing a FOIA raise red flags for the I-485 or with the company? So no. If you don't have the I-140 approval notice, then because it is filed by the petitioner, by the company, you can't use an I-824 to request a duplicate I-140 approval notice. As the beneficiary, the only way you can get a copy of the I-140 approval notice is by filing a FOIA, Freedom of Information Act request, to get a copy of the I-140 petition that was filed on your behalf. And that's pretty simple. You can Google USCIS FOIA. That also, unfortunately, takes quite a few months, and there's no expedite or premium processing for that. But it will not raise a red flag with USCIS. It won't, negatively impact your green card application, and it won't raise a flag with the employer. From what I understand, the employer would not be aware that you submitted a FOIA request.
Questions from Question G. He has received, USCIS has received the adjustment of status on October 26th. He already received the receipt notices. His issue is he did not receive the biometrics. Well, there are a lot of people who did not receive biometrics, don't have to worry about it. I know some people did receive exactly same scenario. Some people received EAD in advance for approval. Some people did not. It depends on the officer that is working on the file. You do not have to worry. If you have a receipt notice, you are safe. If you did not receive the biometrics, you do not have to worry. This is the million-dollar question. Praveen Gulapudi from YouTube. Do you recommend premium processing from EB2 to EB3? I've heard a lot of cases that are getting rejected. You are right, Praveen. There are a lot of cases that are getting rejected. I still recommend people to file the premium processing. Wow. Why would you have your client's cases getting rejected? Now, there is something called rejection. There is something called denial. When we are filing a premium processing, if you're getting a rejection, that doesn't mean anything. They didn't accept the premium processing. Your original I-140 application is intact. Nothing happened to it. Your adjustment of status is intact. Nothing happened to it. But your premium processing is rejected. So what? They didn't took your money. The money comes back. What do? We turn around and file the FedEx next day. And after a couple of times, they're accepting it. There are a lot of cases that got denied. In our office also, we did get a lot of cases, premium processing that get denied, but we have some cases that are getting accepted. There are some cases that we even downgraded, and then we have premium processing, and we even got them approved for them too. So what we do is that once we get the downgrade, we turn around, we apply again, and after a couple of attempts, they do take it into consideration, and they take our money. And that's the way to do it. I strongly recommend people to do downgrading because 6 months deadline is coming. Remember, you filed in October. So April is the deadline for you when you get to 180 days. If you have your I-140 approval, and if you have crossed 180 days, believe me, you have so much freedom. You have so much. I've been an immigrant, believe me, it is so much freedom. You can move the job, you can change the job location. Remember, every time you change the job location, you have to file an amendment. Every time you change the end client, you have to do a lot of things. And there is a lot of flexibility on the job changes in the adjustment of status as compared to the H-1B. In the adjustment of status, you have to be in the similar profession. In the H-1B, the restrictions are a lot more. There is no geographical location restrictions. So you get a lot of freedom. Have your I-140 approved, and once you cross 180 days, you have a lot more freedom than what you can imagine. Watch our video that we released 2 weeks ago.
Someone is asking a quick question. Do we know the status of downgrades yet? So actually, we just, I think in the past week, got our first approvals for the I-140 downgrades that were filed in October. Of course, those were the ones that were successfully upgraded to premium processing. As Rahul mentioned, not all of them are being accepted in premium processing, but we've been able to get some accepted, and we got the first approvals for those just this past week. So that was exciting. And a couple of questions on any updates on H-4 EAD premium processing. Not at this time. It has been passed by Congress last year, and we're waiting on USCIS rulemaking to make it official and provide the process for people to actually apply for premium processing for H-4 EADs. It didn't surprise us that the last administration was kind of dragging their feet on implementing that. We know they were very against the H-4 EAD altogether. So we're hopeful that the new administration, USCIS under the new leadership, will push this through since it's already been passed by Congress, but no news on that quite yet.
Medjin is asking a question about political asylum since pending from past 5 years. We have to say that our office is really not knowledgeable about political asylum. We are definitely not good in that. Anthony has this question about prevailing wage determination from processing timelines. They're getting backlogged currently. Would you expect them to come back to normal soon? Definitely, there are a lot of things that are added to it. We are expecting things to come down. Overall, the administration is not very punitive against immigrants. The way previous administration used to think our immigrants are undesirable people. The official word that is actually given to us is aliens. Now, of course, Biden administration is not using the word undesirable at all. And he actually want to change the word aliens, and they want to use the word as non-citizens. That looks more honorable to me than aliens. And also for the people who are unlawfully present in this country, they're not going to use the word illegal in their definition. So that's very good. So we're expecting prevailing wage and PERM application also to come through more quickly and better. Question from Maheshwari from YouTube. Can an employer sponsor GC while on OPTR STEM extension? The answer is yes, you can. Normally, we use that very frequently, especially if you are non-Indian and non-Chinese born person. Then we recommend, we don't even need to get them the H-1Bs. We can directly get them the green card and get away with the H-1B and lottery system completely.
Shrishti from Facebook is asking, is it true that people are receiving the EAD and AP even before getting their fingerprint appointment, biometrics appointment related to the I-485? So yes, we have had a few cases where people are getting the EAD and advanced parole combo card even before their biometrics have been scheduled. The biometrics is technically that's attached to the I-485. So it's not a condition to get your EAD. From the H-4 EAD processing, we know it feels like that the delay is due to the biometrics, but the biometrics is attached to the H-4, not to the EAD. You don't need your fingerprints taken to get an EAD. You need them to get an H-4, and you need that before you can get an EAD. That's why it is taking so long on that side. For the AOS part, your I-485 doesn't need to be approved in order for you to get the EAD AP, and so that's why some of those are coming in even sooner than the biometrics appointments, which have been very backlogged. I think from the last update, they are still working through appointments that were backlogged or canceled from last year at the ASCs for the biometrics. So expect those to take quite a while.
Karthik has an interesting question. The H-4 extension is pending for more than 1 year. In the state where he stays, they only give driving license for a period of 1 year on the receipt notice. Lucky you are in a state where they are giving you driving license for 1 year. There are some states they don't even give at all. I don't have a solution for this. I would recommend that you write a letter to the state congressman. That means in the state. For example, if you live in the state of Texas or if you live in the state of Arizona, the state congressman is different than that of the federal congressman. I want you to write a letter to the state congressman. I want you to write a letter to the state senator. I want you to write a letter to the US senator. I want you to write a letter to the US congressman. Address this issue on those things. Because what we noticed is that when you are writing letters to the congressman, even if they cannot take any action, they are putting a pressure on the administration. We have recently seen that 60 congressmen wrote letter to the new administration saying, hey, do something about the H-4 EAD. Now, they didn't say something about H-4 EAD. What they said was that while the biometrics is pending, go ahead and issue the H-4 EAD. And if you find something bad in the biometrics, go arrest them. I mean, you're sending the EAD card to a particular address. You know where that guy lives. So it's easy to catch that guy and put him in jail if he is a terrorist or any bad guy. So why are you delaying these things? So some practical solutions have to come up. If you keep writing letter to the congressman, it really works. Believe us, it makes our job much better. When we tell the congressman, they don't hear. These guys are paid people. They're just getting paid to speak with us. Yes, it may be true, but when it is you who's contact the congressman, it will make a lot of difference. Write a letter to the congressman. We do expect some changes, especially coming from the federal government, though, but still state governments are different. So keep writing letter to all the people involved. In this particular case, the state senator, state congressman, US congressman, and US senator. That is the best thing that we can advise you on the driving license. We have two things. One is driving license need to be resolved. Second thing, EAD need to be expedited. So both state and federal government need to be involved in resolving these issues.
Joel from YouTube is asking, from the new administration's immigration bill, what would change in terms of work authorization or an EAD for someone just arriving from India on an H-4 visa? So in immediate practical terms, not too much would change, because if you arrive from India right now on an H-4 visa, enter the US in H-4 status, you can apply for an I-765 immediately. You won't get the EAD immediately, but you can file the application for that EAD as soon as you land, and receive the EAD in hopefully about 4 to 6 months, if not less. As we said before, the holdup with H-4 EADs is primarily when you're filing it concurrently with an H-4 application that requires biometrics. But if you're arriving from India, you don't need to wait for that biometrics appointment. You can apply for the EAD card on its own right away. What would change in the as a result of the new bill, if it does go through with H-4 EAD as part of it, basically the advantage there is that it won't be, it can't be taken away by a future administration, which is what this previous administration has been trying to do ever since they took power. So the H-4 EAD came into being during the Obama administration, and it was not passed by Congress. It was something that the administration tried to do on its own. It's something that they felt was a reasonable thing that people should have, people in H-4 status waiting for their green card. The downside is that when it's done by one administration, it can be undone by the next administration or an administration with different views, which is the whole H-4 EAD court fight that we had for the past several years. If it is passed by Congress, then no matter who's in the White House, they can't try to eliminate it without getting Congress to repeal the entire statute. It would be similar to an L2 EAD, which nobody is trying to repeal that in court. So that would be the advantage if it is part of the new immigration bill.
Here's the gentleman that has the question that why do only, Abhishek from YouTube, why only Indians have to go through this pain of per country limit? I really don't have an answer for it. I mean, Indians and to some extent Chinese nationals, mainland Chinese nationals are going through. Maybe it's a curse. You and I have it. When we were in India, we used to go through the reservations, 50% reservations and 50% open. Remember, you were there. It was not affected you as much as my generation people. The reservations definitely affected a lot because there were too many government universities at that time, government posts at that time. We came here. Now we face the discrimination here too. There it was only the open allocation was only 50%. It seems to be that here it's only 15%. I mean, I don't know what to say. I mean, that's bad luck of you, Abhishek. But let's fight on it. This is a democratic country. You have a voice. I want you to keep writing letters. And the other thing is that I want you to put a pressure on the Indian community people. Wherever you go, they always like to have students so that they can show the number of people who have come in. Whether it's a temple, whether it's a cultural organization, you need to mention to them, look, you're taking all our things, but why don't you support us? Write a letter to the congressman. Why sit up the problems that we have? We have been pending for such a long period of time. You guys got the green card so soon. We are not telling you to have any special quota for us. We just want to be Tom, Dick, and Harry. We don't want to be discriminated. Treat us just like anybody else. Please put a pressure on the Indian community leaders also. We have a lot of congressmen, we have senators. We didn't have senators, so we have congressmen, we have governors, we have people in the cabinet, we have a lot of people contesting at different levels of it. And a lot of people who are giving funding to these politicians. Put a pressure on these people to address this. This should be the main issue. If there is one thing that I would like to have it to be asked, to be put in the bill, the one thing that I would say is that take the discrimination off. Don't look into where you're born at, look into the skill set that you are. Remember what Martin Luther King said, please look into the character of the person, not where he's born at. you should be looking at our characters, not where we are born at. So that should be, and keep up the fight, keep contacting the congressman. That's all I can tell you right now.
I've seen a few questions about renewing your visa through the Dropbox option in India. So we would definitely recommend that if you are eligible for the Dropbox and you need to travel. We would definitely recommend that over trying to book an in-person appointment with the consulates, which, as we mentioned earlier, is getting better, but it's still definitely difficult. So I think one person asked, is it possible if you're with a different employer than the employer that you were with when your previous H-1B visa was issued by the consulate? And the answer is yes, as long as you are applying for a visa renewal in the same class. So your previous H-1 visa was an H-1B and you're applying for an H-1B visa now, even if the employer is different, you can still apply through the Dropbox. And someone else asked, is the duration, the cutoff for your previous visa being expired, is it still 24 months? Yes, it is still 24 months, according to the Department of State. The website that you can go to check the criteria to see if you're eligible for the Dropbox, there's a website called cdn.ustraveldocs.com that is published by the consulates in India that list out the criteria for renewing through the Dropbox. One caveat is that that website, for whatever reason, as of now, it still says that your previous visa expired within the past 12 months, which is inaccurate. It is 24 months, according to what the Department of State has announced due to the limited appointments during the pandemic.
The question that came is that, can I apply for a EAD for my spouse based on my I-140 approval that I received from my previous employer? If the previous employer's I-140 has not been withdrawn, you can apply for your spouse H-4 EAD. If it has been withdrawn, the question that comes is, was it withdrawn before 180 days after it's been approved? If it's been withdrawn before, she may not be eligible to get the EAD. If the withdrawal occurred after 180 days after the I-140 is approved, if your previous company has withdrawn, though, you can still use that I-140 approval to get the H-4 EAD. A lot of people ask this question, once the 180 days happens, the employer cannot withdraw. That is not true. They can withdraw. The only thing is that the effect of it on you will be not very minimal. That means that once the 180 days passed, and if it's withdrawn after January 17th of 2017, you can still use the I-140 approval to apply for H-4 EAD. Even if it's been withdrawn, you can still use the same thing to apply for the H-1B transfer. You can even use to move to company C. Let's say company A got the I-140 approval, you are working with company B. You can still use company A's I-140 approval to move to company C, company D. So absolutely, they can withdraw it, but it will have very minimal effect on you and on the H-4 EAD.
Jay from YouTube is asking if he can join his previous employer that filed or that had an I-140 application approved for him in the past, and whether a new PERM would need to be filed. The job will be similar, but the location is different. So you have to be careful about that if the location is different. It depends quite a bit on that first PERM that was supporting the first I-140 that was approved. If it has some particular language in that PERM application, basically if it states that the job being sponsored is expected to work in unanticipated locations, then the location change may be okay. There may not be the need for a new PERM. If that language is not in that first PERM application, or if the employer's headquarters has changed to a different location, then it is likely that a new PERM is needed to basically do recruitment again for the new area where your job is now. So you would need to consult with an attorney probably to look over that first PERM and determine if a new one is needed.
Question from Wild They will. Is there any way to check the status of the EB3 downgrade? Yeah, you can get the I-140 receipt notice from your company, and then you can check online to see if the downgrade application is, what's the status of it online. You can check it, you can enroll yourself in the USCIS website, and then it automatically gives a text and email messages when there is any update. One more time, I recommend all the people to do the premium processing if you file the downgrade application. We are aware that you're getting premium processing. Some people are getting, not some, very good number of people are getting a premium processing rejection, but that won't have any negative impact whatsoever at all on your overall application. You can refile even after you get the premium processing rejected.
I've seen a couple of questions about whether the filing dates chart would go away, basically if the immigration bill passes that the new administration is proposing. So if the provision that is indicated, so far we don't have the text of it yet, but if they do propose to eliminate the per country caps for green cards, and if that actually goes through, then it does seem like the filing dates chart, that chart B on the visa bulletin, would no longer be needed. It would change kind of the visa bulletin entirely, because right now it is set up based on per country quota caps. It would kind of entirely reconfigure that calculation. So my guess would be that there would no longer be a filing dates chart, because your eligibility to apply for I-485 would be based on when your I-140 was approved, from my understanding of what would be in the bill. But we would need to see.
Questions about the H4EAD premium processing and travel, though. Right now, there is no premium processing for either H4 or EAD. There was a proposal, absolutely, there was a law that passed, but they haven't implemented it yet. We don't know when they're going to implement it. People are asking questions, when the H4 plus EAD is pending, can they travel? There are two classes of people where the H4 and EAD will be pending. One is the people who have filed for a change of status from either F1 or H1 or maybe L1 or other visas to the H4 plus EAD. If they travel when they apply for change of status, it is considered that they have abandoned the application, their change of status will be denied and EAD will be denied. They can still go to the home country or whichever country they want to, which they are eligible for, and they get the H4 stamping, come back, but they have to file for the EAD again. For the people who have filed for the H1, H4 extension, that means that they're already in H4, they file for the extension and they file the EAD. In this case, though, they can travel, their H4 and EAD will be adjudicated accordingly. If their H4 stamping is already over, you could get the stamping there in India or whichever country you're eligible for. And then you can come back, your EAD will be adjudicated in the due time. You don't have to refile the H4 EAD if it is an extension.
So we've seen some questions about H4 EAD litigation and whether we are still filing those court cases. So we are. So you can email our litigation team to get more information. I believe our litigation team is still conducting conference calls, pre-litigation conference calls that would give you all the information needed if you're considering joining that, including timing, deadlines, price, that sort of thing.
If you guys want to consult any of our lawyers, you can go to rnlawgroup.com. All our schedule is open online. You can schedule any time that is more suitable. We do have a daily conference calls. You can go to rnlawgroup.com. You can also subscribe to our news at immigrationgirl.com, which my business partner handles it, and also at rnlawgroup.com. Anything else, Rebecca, before we close?
Nope. Stay safe, everybody. Thank you.
Thank you very much for tuning in, guys.